Hello, everybody. We are going to start this panel session. It is, as you know, about managing PPP contracts, PPP contract management. Thank you very much for WAPPP to having invited us to K-infra to organize and sponsor this specific panel in this specific topic that we are so enthusiastic on it and trying to share and disseminate good practice in it. We have with us 4 panelists, 4 experts. We have Verona Vacianna. Verona is working in the airport authority of Jamaica. She is the general counsel of that authority, and she also works in its subsidiary, which is the NMIA Airport Limited, which is the airport that is they are managing from the airport authority. She has a number of distinctions, certificates, including the certification in airport administration with a distinction from Bell Aviation and the South College. So it's we are very glad to have her because she is representing direct expertise and experience in managing existing PPP contracts that are owned, those contracts by the airport authority. In that sense, we have also João Canto Castro. João is the legal director at Infraestruturas de Portugal. Infraestruturas de Portugal is a public entity, is a public company that is the concessionaire for the roads, the previous road concessions, and then they are subconceding those contracts to private partners. And so Infraestruturas de Portugal, in this sense, in the interaction with the concessionaires, they are acting as the project owner and they need to manage their contracts. And so that's another very relevant experience that we have. He's occupying the position of legal director for concessions and PPPs in Infraestruturas de Portugal since 2008. We have also Richard Foster, director from Foster Infrastructure. Foster Infrastructure is a boutique advising in strategic, commercial, and risk management and related training services in the field of PPPs and infrastructure. Before that, he was acting as assistant director of Partnership Victoria, which is a leading PPP unit globally recognized. He is quite expert in contract management, and in fact, he was one of the authors of the contract management framework that applies in Victoria. He is also as co-lead author of the CP3P guide for the CP3P program. He was in charge of directing and oversighting the drafting of the chapters 7 and 8, which are the chapters related to contract management. He is a partner of K-infra, and as such, he is also leading with me the design. We are now working in a new second version of our contract management course. You can have information about our contract management capacitation, our contract management course in our booth. You have there a brochure, if I am not wrong. And then we have José Yitani. José is the person in charge of managing the PPP knowledge within the IDB, knowledge management and the capacity development program in PPPs in the Inter-American Development Bank. He has, among others, recognitions, a master's degree in public administration by Harvard, and he is also a full certified CP3P expert. Okay, so this is, I'm Andrés Rebollo. I'm going to moderate the session. I'm the managing director of K-infra. Please remember to go through our booth, digital booth. You can know more about what we are doing and what we are offering in the booth, and we have there some corporate videos and some information about our programs, mostly the CP3P program, whose training all over the world we are clearly leading with more than 45% of the candidates and students trained by our company. So talking about PPP contract management, just a brief introduction. one thing that everybody is not probably fully aware is what is contract management. I mean, contract management is defined in a number of guides. Most notably, I would use the definition used by South Africa. Is the methods, the systems aim to facilitate that both parties in the contract, both parties meet the objectives of the contract. So in the end, the objective is to protect or maximize the value for money of the service under the contract. And we need to manage proactively the contract for that, but always taking into account that we need to observe or keep the affordability. That is contract management, basically, a contract management system, if you wish. And the contract management, as opposed to what many people understand, is much more than monitoring. It's much more than oversighting and looking for breaches of contract and putting penalties. In contract management, we need to deal proactively and in an organized manner with managing changes, with managing disputes, managing claims with respect to risk allocation, administering the payments, and also internally, as general aspects of contract management, we need to deal with managing knowledge. I mean, keeping a stable capacity or capabilities of our team, and managing the relationship with the private party, among other, let's say, disciplines or areas of management. So it's really something that is not simple, that is pretty much multidisciplinary, and that there is a general need to be aware about what does contract management suppose, because there is some kind of transaction myopia in the sense that it seems that the work has been done when we sign the contract. And as I typically say, the real work for the government, who is the owner of the project, has barely started at the contract signature. All right, so we will discuss about a number of topics that we have selected among ourselves, among the members of the panel. And we will start with a general introduction of what are the key drivers, what are the fundamental things to be considered in contract management. I will ask each of the panelists to very briefly tell me which are the three top topics that they consider are fundamental for contract management out of a list that I will refresh everybody later on. But before that, José Yitani will share with us with respect to the research and paper that we did together, that under his direction, about PPP contract management within the Latin America region, which are the main considerations that he could share with respect to what we researched among Latin America, in the sense of what is generally needed, what are the obstacles that we need to overcome in contract management. José, can you share with us what do you think are the fundamental messages to be able to get ready for contract management according to your considerations?
Yes, thank you, Andrés. Good morning, everyone in this side of the world. Good afternoon to Europe and the rest. Andrés, thank you, and WAPPP for the invitation to this event. And yes, I would like to share some of the findings that we have on this document. At the IDB, as you mentioned, we developed this discussion document for the PPP Americas in Brazil last November, entitled Reflections on the Importance of PPP Contract Management and Possible Shortcomings in the Region. You can access this at the website of the bank. I would like to share some of the findings that we have on this, and we identified 7 common issues in the region that generate what you can say it's the root problem in contract management. The first one is the general lack of awareness of the importance of the contract management function and the need to build this awareness to institutionalize it. There is something that we can observe, since there is a big absence of contract management guidelines of PPP in the region. There is a lack of integration on the contract management function into the governance, and most importantly, overall the project cycle of PPP projects. Also, we've seen that there is a lack of stable and structured involvement of central agencies throughout the contract management process, which it adds up to this lack of awareness of the importance of the contract. We also find another things that are very interesting. There is a limited vision of the contract management functions. There is this misguiding approach that is only audit-based, which is highly focused only on the control of obligation and not the whole process of the project. There is extreme activity splitting in the contracts that we see in Latin America. There's an extreme fragmentation of activities without the necessary holistic and integrated approach that the activity requires for a PPP. There's also a lack of understanding of the essence of a PPP and what it entails, which should be oriented towards result and the achievement of objectives, and not just the fulfilling of the obligations described in the contract. There is also this problem with the division of traditional engineering in projects, like in the traditional way of supervising a project, which is only supervising what it's the works or the infrastructure that has been built, and not seeing what it's entailed on this type of projects. And finally, there is a clear detachment, and you mentioned it already, of the lack of accountability from the authority. There is a false assumption that is no longer my project once they transfer the design and construction risks to the contractor. Commonly, we've seen that the authorities feeling that it's not their responsibility anymore, that there is no need to apply any other measures to supervise or manage the project. So this is something that they need to be aware, they need to change. I think, and based on our research, that with knowledge and understanding of these 7 general issues that generate these problems, we can focus on the key drivers for a successful contracts. Basically, what we are looking for is to generate good contracts capable to accommodate change and respond to threats efficiently, that include a framework for the management of the project, and not contain only the legal and audit provisions, but also provisions on payment management, on the criteria, rules for implementing changes in scope, the assessment and approval of possible changes in the financing or shareholders structure, or even the procedure for the handback of the assets. There are, answering your question about the 3 important, the most important things that we think that could be like mentioned for a contract like this, it should be, the first one is the lack, as I mentioned before, the lack of awareness of the importance of the contract. And there are 2 more that I would like to mention. One is to have a capable team with resources and enough budget to assure that the PPP is going to be implemented in the right way. This could be achieved through many trainings like the ones you do with the CP3 certification program, or even the immersion on hands-on PPP projects. And there is another one that we think that it's very important, the relationship management. It is important to have a clear and defined way to ensure the proper monitoring of the public-private relation. The assurance of the relation will provide the accountability and transparency to have access to the flow of the information, to ensure that there is no absence or concealed information between the parties, and also to have visibility between both inside and outside of the organization of what's going on and what's happening within the project. I could go on with this, but I know that we're going to discuss more about this in future questions. So thank you, Andrés.
Thank you very much. Thank you very much, José. So you have put for us a general picture about fundamental problems in many countries, lack of awareness about what implies contract management is much more than monitoring, lack of accountability or detachment of the asset. It looks like the asset is not anymore the government asset, but the asset is of the government. I like many countries that uses the concept of delegation. So the asset is my asset, and I delegate the management through a concession contract. But apart from those general problems, then we have these drivers. Now, so your pickup was a sound contract. It's paramount to allow for its own management in a fluid manner. The team, a capable team, and relationship management. That would be your three pickups. So João, and then Verona, and then Richard, just in this order. Which would be your three points out of the list that I will share for everybody now? Is a sound contract incorporating bounded flexibility. Another driver is prepared and capable team. Relationship management, that would be another one. A duly prepared project suitable for PPP. A good manual and procedures and information tools. And a smooth and sound governance of the contract, incorporating upstream agencies into the management. Which would be respectively your three key factors out of this? All of them are relevant, but I would like to ask you which are your three favorite.
Thank you, Andrés. Good morning to you all. I would say a sound contract, which in fact depends, it can only be achieved if you have a duly prepared tender documents. You cannot achieve a sound contract if the tender documents are not well prepared. I would also say a capable team, prepared and capable team. I think it's essential. And the third, I would choose relationship management. Because you have to build trust between the private party and the public party, and this is essential. Very briefly, these are my first three topics.
Okay. Verona?
Thank you, Andrés, and good morning, good afternoon, and good evening. I hope I've captured everyone in all the time zones. Right. From our perspective here at the Airports Authority of Jamaica, being involved in the management of two concession agreements, and that is in relation to a concession for the Sangster International Airport in Montego Bay, Jamaica, that's on the northern coast, and the concession here in Kingston on the eastern coast. We think that a sound contract incorporating bounded flexibility, that is a very key driver, because as you are aware, a contract, can be subject to many interpretations. And so in order to minimize that, the contract terms have to be very clearly set out, the obligations of the party defined, and so that there is no equivocation. Also, the contract has to have some amount of flexibility to account for matters that are unforeseen, at the drafting stage, and that could occur based on the long-term commitments that are contained in the agreement. The second driver that I would mention is that there's the requirement for a capable team. It's important that the team that is managing the concession agreement is armed with the requisite skill set to understand what are the deliverables, what are the implications of those deliverables, and the importance of the private partner or the concessionaire meeting those deliverables in a timely manner. And the third driver, which I will mention quickly, is
the others pick up relationship management.
Right, a smooth and sound governance structure incorporating upstream agencies. Yes, so that is also that is very important. So those are my three.
I like that because so far we had the three votes for exactly the same drivers. You have incorporated a new one. Wonderful. Richard, how about you?
Thank you, Andres, and hello, everyone. I'll be very quick and I'll introduce a driver that is not on your list, Andreas, but I think it's a common thread through much of what José said, and it ties together some of the other drivers. And that is, we need to elevate the importance of contract management within government and develop PPP contract management as a career path for people, so that it's not an administrative role that gets given to one person as a bit of a dead-end job. It is part of an ongoing career path with the right sort of team, the right sort of governance, and all the other elements that the other speakers have said to really drive good outcomes from our PPPs.
Excellent. That in fact is linking to the introduction by José in the sense of, let's say, general framework, cultural attitude changes that we need, no? Rather than the very specific topics. I'm sorry, I will force you. Give me 3 out of the list.
Okay, if I have to give 3 out of the list, I would say a prepared and capable team, relationship management, and smooth and sound governance. Because if you have all of those, then all of the other drivers should follow from them.
Okay.
Absolutely. So we have 3 votes for capable management team, 3 votes for relationship management. Sorry, 4 and 4. And then we have 2 votes for governance and 2 votes for relationship management. So pretty much there is quite a lot of consensus. And if I'm not wrong, sorry, it was 4 votes. The 4 of you mentioned a capable team. So let's start talking about the team. Let me share again my PDF. So in the second big question or second part, we will talk about designing and establishing the team. And related to that, which is a strategical decision to be done before the contract starts its life, but then during the life of the contract, we need to manage knowledge, which is one of the topics or areas of management that we call general management. In that context, the first question or ask for opinion and advice would be the timing. It would be for João. I mean, the CP3P guide, for example, the CP3P standards are really advising everybody that the contract management function should be designed or considered in very early stage of the life of the PPP. In the moment that we are evaluating the costs, for example, we need to have an early identification of the resources that we will need. And then in structuring, as Verona was really indicating, we need to incorporate in the contract the foundations of the framework for the management of the very contract to accommodate changes and so on. So in your perspective, in your experience in Portugal, do you match with these advices of the CP3P guide and you are following this advice, or how are you approaching the timing?
Andrés, we do actually, because in Portugal, the contract management team, the normal is to be designed during the public procurement phase. So before signing the contract, this team is appointed. And in many cases, some of the members of the team, if not all the team, will then be part of the team that will manage the contract. Therefore, this way we can obtain the knowledge during the transaction. So no knowledge is lost between the 2 phases.
Yes.
Let me also say that in Portugal, since the Public Procurement Code went into force in 2008, the contract manager has to be appointed in the tender documents.
Okay.
So at an early stage of the process.
Perfect.
Which in fact means that in Portugal, for PPPs, contract management is a key issue and a key standard for successful PPPs. This is in fact a reality in Portugal since 2008. So I think we match. I think we do.
Absolutely excellent. You mentioned one of the drivers for example, the CP3PK for successfully implementing a team that I did not mention, yes, which is the one that you have put a very significant relevance, which is taking advantage of the knowledge of the project created during all the process of preparation, when either the contract manager should be already incorporated into that team, or there should be some kind of handover to the contract management team with the presence of the experts that were dealing with.
Let me just add why this is now a reality in Portugal, because on the previous PPPs, you had some bad experiences.
Yes.
So it was a lesson learned from the first PPPs in Portugal.
And this is incorporated
that's why now contract management is so important.
Is incorporated into the legal framework, into the general policy and legal framework, the need for dedicating resources for contract management.
It is not in the legal framework, but it's a good practice that we follow since 2008.
Okay, it's not okay, but it's in practical terms it is being applied, but it's not incorporated into the law. No, okay.
And not only PPPs, under the Public Procurement Code in Portugal, all contracts have to have a contract manager designated. Complex, simple, all contracts have to have a contract manager.
Excellent.
Not only PPPs, but PPPs have to have a team, a specialized team. This is important.
Yes.
A specialized team. Members should fulfill all. It must be a multidisciplinary team, legal, financial, technical.
Yeah, team composition. Team composition, yes. That is the next topic. If you want, Verona, to add anything from the perspective of the Airports Authority regarding the timing and when it is designed the team and appointed the people, or to just go directly to the second topic that you are leading, which is share with us how do you face this multidisciplinary need? What is the typical composition of your teams and the structure of your teams generally wise?
Right. So thank you, Andrés. I'll just come in here to speak about the timing for the establishment of the contract management team. So based on our experience, as I would have referenced earlier with the Sangster International Airport PPP and the Norman Manley, I agree with João when he mentioned that it is very important for the team to be on board as early as during the procurement period to get a better understanding of what the project is about. And so what happened was that immediately before the contract was signed, that is at commercial close, the contract management team was established. And why this is important is that after commercial close, based on the modality of our procurement, the contract team starts to work, because during that period from the commercial close to the time that the asset or the operations of the asset is handed over, the public authority is required to satisfy certain CPs, and it is the contract management team that works along with the enterprise team that has responsibility for the implementation of the PPP projects in Jamaica. It is the contract management team that works to ensure that the public authority satisfies all of its conditions precedent, failing which we could have a situation where pecuniary penalties are applied if the public authority does not satisfy the conditions precedent within a stipulated period. And the period under our contract is 12 months. So immediately after the contract signing, the commercial close, the contract team starts to work for a period of 12 months, satisfying those conditions precedent in order for the commencement date to be achieved.
Excellent, Verona. So it's interesting. We move to the third subtopic that we selected in terms of contract management team and managing knowledge, which is knowledge management by Richard. But let me introduce something for Richard and for the audience. I think there is a wonderful, really wonderful governance in terms of contract management in what we are seeing from Portugal and Jamaica. But this is not common. My point is that these representatives from the real life of having to deal with contract management are coming from two organizations that have a very relevant portfolio. So that allows to create and establish an organizational approach rather than when there is a ministry with a not significant portfolio and they need to appoint a team from scratch. That is the challenge probably. But even so there is a role probably for the capacity of financial advisors or specialist legal advisors to accompany this team that in many cases, as far as I know, is just comprised by one person, the contract manager. And no matter whether we are talking about institutions that are not managing a relevant portfolio of projects, or even if we are talking about Infraestruturas de Portugal or the Airports Authority, there is a general threat. And the general threat in terms of knowledge is that we need a stable, capable team, and there will be changes in the team. And people will move, people will go away. So that is an incredible challenge about managing permanently the knowledge and capacity of the team. And I would like to ask Richard, how do you think this should be managed?
That's an excellent introduction to the issue, Andrés. Let me quickly just run through some of the methodologies. The first one is the importance of having proper succession planning, so you don't have someone leave a contract management role and take all the knowledge with them off to somewhere else. So something that we tend to do here in Australia is we always make sure that no matter what size of the PPP, there is never a reliance on one single person as the contract manager. For example, our state health department has now 7 PPP contracts. They have a team of 4 managing the 7 contracts, but within that team of 4, for every contract, there are 2 people within that team of 4 who are involved on a continuous basis in dealing with that contract. So if one of those people is sick or on leave or finds a new job, then the knowledge stays within the organisation. The second thing is having good documentation. That typically for a PPP would include a contract management manual of some sort, because there's a lot of important information about the contract and about how it's managed that isn't in the legal documentation. For example, the contract might say you have to make payments to the private partner at certain times, but the contract won't detail all the internal processes within government for validating the payments, approving the payments, and so on. So you need a manual to document all those sorts of processes. And then because over the life of a PPP, there will be a lot of correspondence backwards and forwards between the parties, you need very good document management to make sure that if a letter comes from the private partner today and it's relevant in 7 years' time, you can go back and find it and you have all of that information. So they're really some of the key things that I think are particularly important in terms of knowledge management.
Okay, succession planning, document management, including a sound manual, no? And the other one was?
I guess as part of the succession planning, having that crossover of roles.
Okay.
So not a reliance on one person.
So you don't rely in one single person. I would add another one. I mean, that is typically covered in the materials that we are managing, which is the role of the training, no? I mean, the permanent training, it is related to succession planning in the sense of having a good training package, no, for people that come in as new members of the team during the life of the contract, but also general staff of training. I mean, so the people are permanently familiar with project management techniques, stakeholders and things like that. The training probably would be also connected, but it would be the another one, I guess. And well, you know about that because you deliver every year a training on contract management in Australia for the various staff of the Australia.
Absolutely, we actually have a master's level PPP contract management training program run with the University of Melbourne.
And our course on PPP contract management.
Absolutely. K-infra taking the field as well.
Yes, together with you. Okay, so let's move. We keep on with you, Richard. Wait a second. Yeah, and let's move to another of the topics that we selected for the discussion: relationship management. Okay, we are changing topic. We go to relationship management and communications, and we call it in a methodology, in a capacity building methodology, we call it one of the general areas that permanently you need to manage because it will help the other material management areas. One of the material management areas is managing a dispute, but they are incredibly connected, relationship management and dispute management. So we will touch bases here as well in dispute management. And we will start with you, Richard. How relevant is relationship management? What are the key drivers that we should follow up for a successful relationship management, and the need to incorporate this concept into managing of PPP contracts? Because everybody is very familiar and discussing about the stakeholder management, but I don't think that everybody realized that one of the main stakeholders of the authority of the contract is his private partner. Richard, what do you think? And which are the methodologies, approaches?
You're absolutely right, Andrés. The private partner and the members of the private partners consortium, they are very important stakeholders. The way I often think about this is that in a perfect world, a PPP contract provides alignment between the public and private sectors so that the private sector performs under the contract and delivers the outcomes that government is looking for while also making a profit for itself, and we're all happy. Unfortunately, though, because on both sides we have human beings and human beings are imperfect, sometimes things don't work quite as they should. Let me give a very brief example that illustrates both a small relationship failure and also a relationship success. I was involved in a PPP. It was operating successfully. And then a piece of telecommunications equipment that the private partner had provided and operated under the PPP, this piece of telecommunications equipment failed. Under the PPP contract, therefore, they failed to meet one of the key performance indicators, so the government was entitled to make a payment deduction. But we didn't just make a payment deduction and say, well, that's what the contract says happens, so we've done what the contract says. The private partner actually investigated the cause of the failure and came to government with a report and explained to government what the problem was. So that's a relationship working well for a start. However, what we then found was the actual cause of the problem had an easy solution that would stop it happening again in the future. There was a risk that this problem would recur, and we didn't want it to reoccur. The private partner could have fixed the problem by buying an extra piece of equipment which cost about $15,000. And for some reason, they didn't go ahead and do that, even though the risk to them of future payment deductions amounted to a much larger sum in total, potentially over the life of the contract, than $15,000. And as government, we couldn't understand why. So the relationship wasn't working perfectly. We didn't have open and transparent communication. But what we had done well was we had established communication at different levels within each organisation. And other speakers will talk more about this. So we decided that what we should do is elevate the discussion to a senior person within the government who had a very good relationship with a senior person on the private sector's side. And the government person just asked, we don't understand why you are not putting in this additional piece of equipment to solve this problem, prevent it occurring in the future, mitigate risk for both you and for us. And it turned out it was a very simple thing, which was that the lower level operations manager on the private sector side only had $10,000 financial delegation. So he could only approve expenditure of $10,000, and it was going to cost $15,000 to fix the problem. So instead of going to his boss and saying, can you approve us spending this money to fix this problem? He was trying to just avoid the issue. He didn't want to look bad. He thought he would look bad in the eyes of his boss. What happened was, because we had that conversation at the senior level, the senior person on the private sector side said, oh, of course we should spend $15,000 to prevent a greater value of future payment deductions. Let's fix this, and that provides a much better outcome for government and the private sector than if we just let this issue sit there and we didn't fix it properly. So there, having the right relationship ultimately provided a much better outcome for the government than just sitting back and saying, well, the contract is the contract and what happens under the contract will be dealt with under the contract.
Excellent, excellent. I think that we are talking, again, as it's something that we are working in this, are pretty aware, but probably the audience in general terms is not. Here we are talking about two things. No? Here we are talking about attitudes. I mean, a collaborative attitude, trust, but also we are talking about managing communications in terms of having the correct defined channels, avoid diagonals. No, so here you escalate the issue inside the organization of the public body, and the corresponding peer, which is a senior person, senior to the guy that was creating the problem because not being capable to manage it, will receive the message. And so horizontal is a must. Being able to escalate is a must. I just want to say this because many things in contract management relate to many common managerial knowledge, like project management, relationship management, and so on. So we talk about attitudes and we talk about communication. And attitudes, you cannot order them. Attitudes, you cannot regulate them in the contract. But communications, you can regulate the rules for those communications. You can establish certain forums, certain meetings, and so on. So here I would like to go to Verona. What is how do you approach communications and governance with respect to the relationship, especially from the point of view of communications, meetings in Jamaica generally wise, or in your contracts in the airport authority? Verona.
Okay, thank you, Andres. Right, so from our perspective here at the Airports Authority of Jamaica, we consider effective relationship management in a PPP project very important because we think that it facilitates the early resolution of disputes in the future. And therefore, that is why it is promoted and it is addressed in our concession agreements, both of them, the promotion of good governance by upholding the principles of accountability, transparency, fairness, efficiency. And these are very important to sustaining a mutually beneficial partnership with that is between the public authority and the private partner. And so to this end, the concession agreement requires that there are periodic meetings that are to be held by the public authority, and the private partner. And these meetings are held with the senior managers. The concession agreement specifically requires that these meetings are held with the senior manager of the private partner and the public authority to discuss, key issues such as matters relating to financial performance of the concession, the operational issues, project-related matters, especially as our concession agreement was granted for the private partner to undertake certain capital improvements. And so when these meetings are held, the public authority obtains updates on the progress of these works. If there are any issues that are, impeding the progress of the work, whether or not the private partner requires any intervention, and these are addressed before they reach, a critical stage. And if there's anything that the public authority can do, the public authority does in terms of, addressing these. Also, as it relates to the any disputes that arise in these, treating with the concession, then the concession management team is able to treat with these and under the amicable settlement dispute resolution scheme that is contained in the concession agreement.
Excellent.
Andrés, can I just add something?
Yes. João,
I think it's also essential.
We are running out of the schedule.
Just a minute. I think it's also essential that the private party designates a contract manager. Not only the public party, the other side. You have to build trust from the beginning. And for that, you have to have a channel of communication between the two parties.
Absolutely.
And for that, and it's essential for the private party to designate a person for it.
Absolutely. Absolutely. And that's the reason for me to have good contracts that are defining or regulating the obligation to have certain regular meetings and also the commitments to define and appointing contact persons for each issue, etc., etc. It's two sides, no? But I really believe what I have seen in life is that the position, the attitude of the private party in terms of willingness to have or enter into committees or discussion forums is much bigger than traditionally that of the public sector. Generally speaking, I mean, globally speaking,
I think what I think is you have to build trust in such a way that it would be possible to pick up the phone and speak before arising a dispute or a matter.
Absolutely.
I'm having this problem, please. How can I deal with it?
Trust is paramount. Trust is paramount, but also the formal channels that regulated is before we go into the dispute. And precisely, José, the question for you, it would be elaborating a little bit in managing disputes. The best management of a dispute or the best dispute management would be managers aiming to avoiding the dispute becoming a dispute, but just being an issue. Because a dispute is an issue that was not solved in due time. But disputes finally will occur. It can be that you cannot really agree on which is the quantity for the compensation or whatever. And we need some mechanisms like the amicable discussions, let's say prescribed or regulated by contract, like in Airports Authority, or in Portugal, your negotiation committees. And we have, generally speaking, this dispute resolution board approach that is not uncommon in Latin America. Can you elaborate here a little bit, José, about your experience and knowledge about how are they doing in this respect in Latin America generally?
Sure, thank you, Andrés. You basically answered the question already, and I will use some of Joao's comments. He's right. I mean, first of all, a good contractual management should include in the first instance, a dispute management mechanism that aim to minimize the risk of disputes and the possible problems occurring by ensuring a good interaction between the parties, which I was referring before to relationship management and goes in hand with what João was saying, not to pick up the phone and address possible misunderstanding in advance, maintain fluid communication, and manage clear information at all times. I think that this is basic, no? And what you said, in other words, the dispute management is mainly about preventing dispute from happening in the first place. Now, when it comes to disputes in Latin America, we've seen that most countries follow the best practices as much as possible. And the panel of experts holds a very positive view of these disputes, how disputes are managed in the region. Also, we've seen that across the region, countries generally follow this. They include in their contracts a hierarchical dispute resolution process, what you are referring to, amicable conversations, with several consecutive interactions about the dispute that they're having, and they encourage the parties to negotiate directly to solve their dispute and find a mutual agreement in the first instance before anything else. In some cases, when they cannot do this and they face that an agreement can't be reached through these one-on-one negotiations, we observe that many countries have established the dispute resolution panel, which basically consists in 3 experts. One is appointed by each party, and generally the third one is agreed between the 2 of them to hear the case and deliver the final decision. However, in some other situation where there is no panel or this mechanism is exhausted, the case could be submitted to arbitration. It could be national or international, which is considered the best practice. And the decision of this arbitration is usually non-appealable. And in some extreme situations, what we've seen in very few cases, it's that they take it to a court. So this is the last resort, for say, and usually takes longer than any other process, and it's a very, very tiring process where the relationship between the 2 parties is devastated, basically, and it's very tough for both. That's why all of these mechanisms, or in each way, it tries to avoid any way of dispute or try to prevent them on the first place, or to take them to the next level. Obviously, trying to prevent that the relationship between the parties. We know that there's going to be a lot of situations that could be agreed or not agreed during the long project cycle that we have on PPP specifically, but they try establishing management mechanisms to manage disputes. We think that is the best way to anticipate these disputes or try to avoid them using some of these mechanisms before escalating to something tougher or worse.
Excellent, Jose. So I think that the messages are clear. I mean, relationship management and good communication management is fundamental to avoid or mitigate the impact of disputes. But then, if a dispute comes, good practice generally wise is allowing for arbitration, because it's something that in many countries like Spain, with traditional administrative legal administrative approaches, it has been really recent to allow for arbitration. Now it's common in all the world. We need arbitration instead as a possibility instead of in lieu of courts. But before we go to any of the 2 arbitration courts, we should have in place in the contract some formal mechanism to try to solve the dispute within the framework of the contract rather than going out of the contract. If it's not possible, it's not possible. But that will save a lot of money to both parties. Jose, precisely one of the areas of recurrent typical disputes is risks. I mean, risk allocation, risk events occurring, and this is a compensable event. It's not, but it was a retained risk. It's not a retained risk. Let's talk about managing risk and contingencies, and specifically here, Jose, managing claims from risk allocation. One clear message in the CP3P and other guidelines is that, as many other things that we say at the very beginning that should be incorporated into the contract, a contract needs to have a proper framework for risk allocation, very clearly defined who is responsible for which risk. But risk is a very gray area in general. There will be disputes, but we need to close as much as possible definitions. We need to be clear in the contract as much as possible to mitigate the risk of dispute. How do you think that in Latin America do they deal with this? I mean, is there good and proper standards regarding risk allocation that are incorporated into the contracts? What is your impression about how Latin America scores in this area of frameworks and contract management? Jose?
Yes, we cover a few countries in Latin America, well, not few, basically the region, and we observe that in some countries, they establish clear contractual standards. This is to minimize any kind of error during the contract drafting, and generally generates a consistency in the use of the PPP. This prevents from misunderstanding or to have problems defining any type of situation when this happens. We have found that some countries have good experiences with clear standards defined in public policy documents regarding risk allocations, like Colombia and Peru. And some other countries reach good results by having created contingency funds, like also Colombia and Paraguay. I would like to point out that even though this is a possible trend in the region towards the standardization of risk allocation, that's something that we should consider to be extended and include to other relevant areas of contract design that have a big impact on project management. Not just to see risk allocation like something that needs to be standardized or to integrate certain standards to specify what is the meaning of these risk allocation problems, but also some other areas. We should think that there is the need to standardize these aspects that play a major role in making the contract an operational framework for its own management. Things like shareholding changes and the approval processes, the early termination events, the dispute resolution process, contractual changes, and some other things that I believe are relevant for the contract, and that sometimes are in, like you mentioned, in this gray area that needs to have certain and specific standards to be treated as such.
Excellent, Jose. Thank you very much. We see that one fundamental point of contract management in terms of risk management is to have a clear framework established within the contract, but also risk management, and from a broad perspective, contingency management, and not just risk allocation management, is paramount. And again, if we think in terms of contracts, a good contract would provide for a clear path to manage the early termination of the contract if something dramatic happens, like a force majeure event, or like a serious default of the private party, or the private party enters into bankruptcy, or during the course of the contract, maybe we need to step in. Again, we need the contract settling some rules and some framework to deal with those situations. However, in this respect, risk management, contingency planning, the best practice advice in many guys, including CP3P, is you need to plan contingencies in advance. How relevant do you think is this, and how common or uncommon, João, do you think is this? Because I can tell you, for example, I mean, Latin America, Spain, I would say some other countries in Europe, but I will not mention them, is not applying good practice. What do you think? How relevant is this, and if it's being used in Portugal, the contingency planning?
Well, I think it's very, very relevant, because whenever you are dealing with public interests, the key issue is if you have to early terminate the contract, the public interest, the public service has to continue. So the contingency plan is the way you do the transition between the contract and the next phase. In Portugal, it's not common to have a contingency plan for early termination. However, if the state or the public party wants to terminate the contract due to public interest, for instance, the notice to the private party has to be given with a year before. So if I wanted to terminate the contract now, to be terminated in 2023, June, I had to send the notice now. That gives you a year to prepare the transition. It's not the best scenario, but it's a way of giving the public party some time to prepare the transition. But in Portugal, it's not usual to have a contingency plan for early termination. But I think it's relevant. We should have.
Excellent. Thank you very much. Yeah, somebody is advising and recalling me. We are a little bit running out of the scheduled time if we want to allow for questions. Also, the hosts are suggesting that we advise the people to move if they want to. To attend questions and answers that we will try to attend at the end of the meeting, to move to the meet and greet lounge. However, I have to recognize that I don't know how to do that. But maybe you can explain us towards the end in 25 minutes. Let's try to speed up and so we can prepare properly the follow-up for the questions and answers. And again, people that want to be with us, we will be following up questions and answers in this other launch. Okay, I will not be able to be there because unfortunately now it is starting a board of directors that I should be present, so the people will be waiting for me by 30 minutes at that time. But the rest of the panelists will be there. Okay, so very quickly, we have only 2 topics more. Maybe we can manage in 10 minutes to cover the 2 of them. The first one is to start with you. That's a new area, a different area than the areas before. Everything is relatively interconnected, obviously. But talking about performance management and control of obligations, I mean, performance management. Let me explain one thing that will come naturally, but so we speed up for the people. I mean, performance management it sounds counterintuitive that the public party has to manage performance. But that is true. I mean, we need to manage performance by means of the delegation. We have delegated the service delivery, and we need to manage the performance of the guy. And the performance is trying that the performance of our private party is excellent. And that is not just a question of putting penalties all the time. Okay. So in terms of performance management, what the first thing is to be able to have the information. That's what generally we call monitoring the service. No, how should we do a monitoring, particularly in terms of 2 clear positions that I see in the world? One is we have to rely in the information captured by the private party and establish mechanisms so we have direct access to that information. Other people saying, no, we cannot trust in the private party. We need to pay directly to certain inspectors and get for us directly the information. What do you think about these 2 positions, João, and how do you handle monitoring in Portugal in the roads?
Well, in EP, the measurement is based on information that we collect from the private parties. So not by external inspectors who are dealing with the matter. They give us the information, we collect the information, then we have a kind of computer program that deals with the information to make the availability payments. I think it's a good way to, if you have a contract with a private party, Trust is essential. If you don't believe, if you don't trust the private party, then you should terminate the contract.
Perfect. Absolutely. Crystal clear.
When trust is not there, better to terminate the contract, I think. So this is the way we do it in Portugal. We collect information from the private party, and we check the information. If there is something we think is not right, we ask some clarifications. But mainly the information is given by the private party, who is actually operating the road. So this is the way we do it.
Perfect. Now let's go back to Jamaica, to Airports Authority. How do you handle monitoring, and particularly, how do you handle some topic that I think is really extraordinarily relevant and very necessary to manage proactively, which is persistent breaches, which is controlling in the long term which are the trends of the performance. We have this tool, this mechanism called performance points, for example, to have a track record. Do you use these techniques in Jamaica, Verona, or some other techniques or approaches for permanent and continue monitoring, being able to see the trends of the performance?
Yes, Andres. So as it relates to our agreements, incorporated therein are service standards, and the concessionaires are required to meet these standards. And especially in our business, we have the IATA, International Air Transport Association. So the standard, they're required to maintain a certain standard in keeping with that association's standards level, rather. And so in the event that they do not meet these standards, because what we do, there are reporting requirements. So the concessionaires are required to provide reports. What we also do, we conduct site visits, we conduct site inspections, and also there is a requirement for the public authority to undertake audits. So these are the monitoring tools that we use. So site inspections, audits, site visits, and the reporting obligation. And in the event that the concessionaire is in breach and that they are persistent breach, the public authority has a number of tools available to it. And the first one being basically, if there's a breach, then the first order of business is to issue a notice. If the notice is issued and the breach is not cured, the next level is for performance damages to apply. And after performance damages is applied, well, if the concessionaire does not respond, then because of the requirement for the concessionaire to put in place a bond, then the public authority may call upon the bond. If after the bond is invoked or drawn upon and the breach continues, then there is another tool or another mechanism. The public authority may step in and take over the operation of the airport. And of course, until the circumstances giving rise to the step-in is cured. If that does not work, then the last remedy that is available to the public authority is really termination. However, we do not resort to that. I don't think that is that decision should be taken lightly, because in such a scenario, termination payments would be applicable. So whether it is termination due to an event of default by the concessionaire, termination due to an event of default by the public authority, or whether or not it is due to force majeure, and the force majeure event, which is no fault of either of the parties, then the public authority is required to pay termination payments in keeping with a formula that is entrenched in the concession agreement. So that is how we treat with performance points and persistent breaches.
Excellent, Verona, thank you very much. So I think it's good practice and a good example of how in contract standards and approaches for this, you have a progressive route of remedies and increasing the penalization, increasing the harm, and proactively trying to avoid that there is a persistence in the breaches. No, we don't have time to discuss about that, but I would like to bring a point here regarding what I call always the perversion of early termination by default of the private party. I mean, many contracts are not early terminated because that trigger a liability to make a significant payment that you don't have ready in the budget, and it's something that is very easy to solve. We did it already in Europe, fortunately, 2 years ago, and is that contracts are not terminated. What is terminated is the relationship with the owner of the SPV, that you move them out, and which is the indemnity. The indemnity is what the market is going to offer to your private party, to the owner of the SPV, so somebody else will come in and pay a market value of the remaining number of years of the business. So you pass through the obligation of paying the early termination compensation to the market. And that's what should be done, in my opinion, in any single country in the world, with some exceptions of minimum insurance of minimum quantity in emerging markets. But generally wise, we should do that. Okay, but going to termination by default, which is the ultimate remedy, which are your thoughts, José, from the things that you have observed in Latin America regarding the management of termination for default of the private party?
Well, when there's a termination by default, in most countries, what we've seen is that they focus in one main thing, that it's probably the most important by itself, is to ensure that the contract will remain in effect, that the service or infrastructure will continue its function independently of what's going on. There are many reasons to take this step in a project: poor stakeholders management, poor communication, bad project preparation, government inability to pay, also for unforeseen events that cannot be solved by any of the parties or according to the rules of the contract. You name it. There are many possibilities. Now, going back to what we've heard and said during these conversations, like the disputes, another objective of contract management is to prevent the contract from having to be terminated for reasons that could have been foreseen or avoided in the first place, just like the disputes. What we've seen in the region is that clarity in the contract, it's key to regulate termination too. We've seen that when you have in a contract a clear definition and a minimum protocol to respond to an event of termination, it's one of the best standards that we've seen. Probably we suggest a standardization process with clear criteria to identify without ambiguities, because this is something that it happens a lot. What can trigger the termination of the contract? What are the main reasons, and what can be accepted as a reason to terminate the contract under these circumstances? All of this should aim to guarantee the continuity of the service and to minimize the damage that this could cause to the users and to the viability of the project by itself. This is the reflections that I can share with you of what we've seen in the region, Andrés.
Thanks a lot. Thanks a lot, José. Let's move to the last topic with Richard. We welcome Richard again. This is a very relevant topic. We have 4 small bullet points, but obviously you are, as you suspected from the very beginning, under a big pressure because we have not much time. So this is a very relevant topic, change management. So the question is, how do you think one should lead with contract changes, considering, as we have suggested in the bullet points, considering that it seems convenient to put some control or limits to contract changes, it should be also a proper governance in accepting the changes, evaluating the changes. So far, let's go for that, and then I will introduce the other questions.
Okay, thanks, Andrés. Yes, when we think about PPPs, naturally we are involving ourselves in a long-term contractual relationship. So the question arises, how do we deal with changes? Firstly, changes in the scope of the private partner's responsibilities, particularly with respect to the works, the physical infrastructure, and the services that the private partner provides. And this is in the context of the broader principles that we apply to public sector procurement, where we use typically competition in public sector procurement as a key way of establishing that we are getting value for money from government investment. So if we have an existing PPP and we want to change the infrastructure by perhaps expanding it, then we have a bit of a tension. We have a tension between the general principle of public procurement that when we want new works or new services, whenever government wants new infrastructure, we run competitive tender processes. And on the other hand, the fact that we have the PPP in place and we don't want to undermine that PPP by, expanding the road and having 2 lanes of the road under the PPP and the lanes beside it not under the PPP. Obviously, that wouldn't make much sense. So there are many changes that it makes sense to do through the PPP, but when we come to very large changes, we start to think more about those important principles of public procurement and value and the importance of running good competitive processes. That means perhaps some changes are too significant to be done as part of the PPP. So what some governments do is they put a value limit on the size of changes that you can have in a PPP. And I think in the European Union, for example, you cannot have changes that are more than 50% of the value of the PPP.
That's correct.
So we have an upper ceiling. Then there's a question below that ceiling, if you have a ceiling. Do you treat all changes in the same way under the contract, or do you have different categories? In many countries in early PPP contracts, there was just one clause in the contract that allowed you to make changes. But people found that for very large changes, you need a quite detailed process with a number of steps in order to work through the impact of that change on the PPP. How does it affect payment? How does it affect the risk allocation? How does it actually affect the detail of things like key performance indicators and payment deductions and so on? Whereas for smaller changes, it's very inefficient to have to work through such a detailed process. So what we see in countries like South Africa, for example, is there are different categories of changes within the contract, and smaller changes, what are often called minor works or minor changes, go through a simplified process. Larger changes go through a more detailed process with more steps, more checks to make sure that the change isn't going to undermine the intent of the overall PPP. Here in Australia, we actually have 3 categories of changes. We have the very small ones that have a very simple process. We have small changes that have a bit of a more detailed process because they require some changes to the contract scope. And then we have the larger changes. And then we also have a 4th category, which we call augmentations, which are the sort of things where you are fundamentally changing the PPP by, for example, expanding it by 50%, the sort of thing that in the EU, the regulations say you don't do it through the PPP. Here in Australia, we say you can do it, but you have a very rigorous system of governance around it, which brings us to the next point, change governance. So when we think about changes to PPPs, I like to think of it as being, look at each change and think, if we were doing that separately from the PPP, just as a standalone public procurement, what governance would we have around it? And whatever governance we would have around that change, if it was just a standalone thing, for example, suppose our PPP is for a school building and we want to build an extra classroom. If we built that extra classroom as a standalone project, what governance would we have around that? And then if we are building that extra classroom as a change to a PPP, we should have an equivalent governance framework in terms of approving that change, consulting with stakeholders, all the other elements of governance that go towards making any sort of government investment proceed smoothly. So in the case of a PPP, that might also mean you have to go and get approval from your central PPP unit. If your central PPP unit actually does have a role in overseeing investment through PPPs, whether it's a new PPP or a change to an existing PPP, it's government investment through a PPP. Your central PPP unit should have a role. Finance ministries, if your central PPP unit is separate from your finance ministry, they may have a role as well. So I guess, Andrés, speaking of finance, that perhaps leads us nicely into the next point of who and how to finance the change.
Yeah, but I will, if you don't mind, I will, because I want to leave 5 minutes to, so somebody from the organization will share with us how can we keep on and change room for being able to attend all the questions and answers. So I will summarize what we were discussing yesterday or the other day when we were preparing this very quickly. There is one topic that is how finance the change or how to finance or who will finance the change. And the question is that a good practice is that you don't impose to the private party to finance the change, to finance any risk event, but you negotiate with them. It's something that is not occurring in all countries. There are many countries that you can impose to finance the change to the private partner and then rebalance. The other point here is that is becoming very, very good practice what they are doing in many countries, not so many, but progressively more countries, creating contingency funds, allocating some portion in the budget of the value of the risks and creating a bank so you have funds there available to pay for a change or to pay for a risk allocation. And about changes, other changes and strategy, we don't have time, but that's the last topic. Maybe we have the skills to go through those strategies in the questions and answers. So I don't know if JC or Jyoti or somebody will going to explain how to move to the other room. Okay, you cannot make any change in the ongoing session, Jyoti, all right? But it was not possible to for GC to just speak?
JC?
Yes, Jyoti, hello.
So to go on the meet and greet, right after this session, you see this arrow right at the top left corner next to the button live. Just click on that, and then on the top you have the main tabs on the AirMeet screen next to the WAPPP Annual Congress and View Schedule. There should be a button called Meet and Greet, and then when you click on that, you will see a big icon for lounges, and you will see a K-infra lounge. So you just click on that lounge, and somebody from K-infra should let you in.
No. Okay. Just to make it very clear.
Yeah.
When this session finishes, you automatically come to a top level menu, and there that you have 3 choices: either visit the next session, go to the meet and greet, which is a social lounge for networking, or go to an expo booth. It's very intuitive. And when you arrive in this meet and greet area, you can sit down at any table. But if you want to continue this conversation, you can go to the K-infra table, which will expand. and then we can continue to have a nice and gentle conversation.
Excellent. But just one question: how it is any manner that we can keep the questions and answers, or we will lose them?
Can you repeat? I didn't understand your
question.
question.
With respect to the questions and answers that are already posted,
yes,
we will lose them. No, I think we will lose them.
No, I think this is not lost. We can follow up later. But we still have 5 minutes to go on. So if you want to take some of the questions, I can display them for you, and then somebody from the panel can pick them up. Okay,
yes,
I'll go for the ones that are most upvoted. So here we go. What are the key considerations for contract management on a PPP where a government agency or SOE has equity ownership in the PPP company or SPV?
Oh, let me start with this one. The best thing is that the government would not be an equity owner, has any equity ownership in the PPP company. That's my first one. If a government has an equity interest in a PPP scheme in the SPV, it is not a source of conflict. It is, for definition, a conflict because you are part of the board of directors, and on the other hand, you are the procuring authority. But there is a manner in which you can have equity participation as a government, which is an independent manner through an infrastructure fund. Okay, but not the agency that is procuring the project, but somebody representing public funds. That's another story. If anybody want to add up anything. No? Okay.
I think that's fair. We consider this answered. Now, the next most upvoted question was, how frequently do we see standing dispute boards designed into the PPP escalation mechanism framework? Is that something you see regularly?
In Latin America, we have seen that in majority of the countries, they incorporate dispute resolution boards within the PPP contract.
Is it used sufficiently, or do you think it should be used more frequently?
I think so far, I mean, Portugal, they have it.
Yes.
Jamaica, I think they have it. Latin America, most of the countries, they have it. Australia, of course, they have it. So I think it's one very, very good practice that is very rapidly spreading all around the world. So that's pretty positive in general terms.
And maybe with regard to dispute boards, just to let you know that WAPPP has a network membership with the Dispute Resolution Board Foundation, and they have set up a dedicated team within that looks just at PPP dispute boards. And this is really interesting because they're trying to really go at the edge and try to innovate. And it's very important to have this dispute avoidance approach, because we found out when we ran a webinar last year that actually the better prepared the teams are with regard to dispute boards, the less likely it is you will have a full-blown conflict.
Absolutely.
Okay. Next question is, how did private operators take advantage of renegotiating certain clauses of the agreement due to the corona pandemic to improve contract terms and transfer some demand-side risks? Do you think it's time to define force majeure in PPP contracts so as, and I think it goes on, but I don't see how it continues. But we have the core of the question, so maybe somebody wants to take it up.
Maybe I'll...
Yes, Richard, please.
I'll make some quick observations. When the pandemic first arrived, there were various online events about the impact of coronavirus on PPPs, and I saw in one of those events someone saying, well, of course it's not a force majeure. And the next event, I saw someone saying, well, of course it's a force majeure. So it very much depends upon your legal system and how your legal system treats force majeure, I think really is the lesson there. But that leads to the question of, should it be generally defined as a force majeure event? And I have a philosophical objection to that, because force majeure events are meant to be the highly unlikely but very high impact events. The reality is we have pandemics on a regular basis, and if you have PPP contracts that are, say, 25 years in length, there's a reasonable chance you are going to have a pandemic at some point during the life of your PPP. And so that's not really what a force majeure mechanism is for. I think the problem that the pandemic has highlighted is that we don't have good risk mechanisms, good mechanisms for dealing with risks when they are in that in-between ground between the extremely unlikely but extremely damaging territory of force majeure events and the sort of business as usual risks that people know how to deal with because they're less severe and they occur a bit more frequently. And so that's not really answering the question, but I think it's highlighting what sits behind the question, which is that PPP contracts haven't yet evolved to deal very well with those sorts of not particularly likely, somewhat severe risks, but they're not really something that should be treated as a force majeure where really the whole underpinning of the contract is now thrown up in the air.
Thank you so much, Richard. That was, I think, a really nice final answer to our panel that comes to an end. Andrés, maybe you want to say thank you. I, from the website, would like to thank you very much for having sponsored this super interesting and engaging session. Thank you for the wonderful people you've brought to the table. I think it was very enriching. And I would suggest we continue our discussion now in the meet and greet area, and you will be automatically conducted there.